One of a couple important United States Supreme Court cases I want to talk to you about is one probably you've never heard of. Most of the time when we hear of Supreme Court cases and we think of civil rights, we think of Brown v. Board of Education. And while Brown v. Board of Education is extremely important, the reality is that the framework for Brown v. Board of Education was actually set a few years earlier in something called Sweatt v. Painter. So I want to tell you a little bit about this. This takes place here in Texas, where I'm sitting, particularly at a place called University of Texas in Austin. Okay, so Heman Sweatt had attended college and he wanted to be a lawyer. And so he applied for the most prestigious law school in Texas, which is the University of Texas in Austin. However, because he was African American, he was forbidden by law to enroll in the university's law school. They didn't even look at his application. They looked, oh, he's African American, and basically threw it away. So he sued them under the Equal Protection Clause of the 14th Amendment. Now, remember, 14th Amendment was the amendment that was used to justify Plessy versus Ferguson. Plessy versus Ferguson was a Supreme Court case in the 1890s that legalized segregation so long as everything was separate but equal. Okay, there was no law school for a person who was African American in Austin, or even for that matter in Texas. So there was no way that you could say that there was a separate but equal. And so he sued using the framework, trying to use Plessy v. Ferguson against the people who were promoting segregation by saying, hey, listen, you're not providing me with a separate but equal opportunity to become a lawyer. All right, which just goes to show you don't mess with lawyers because they actually know the law. And so this is going to actually go, and he's going to sue the dean of the school, a guy by the name of Theophilus Paint. All right, that's his real name. I'm not making this up. All right, based on the idea that there was no separate but equal, therefore they were in violation of the existing segregation laws of separate but equal under the Plessy versus Ferguson. Well, this is going to go all the way to the United States Supreme Court. Now, the University of Texas, to try to avoid this, actually creates in the basement of their existing law school a special school just for him. But the Supreme Court comes in and says, okay, let's think about this for a second. This law school has existed for only a few weeks. It will not have the prestige that the University of Texas Law School has. It will not have access to the library. When you are a lawyer, the first year of law school, they call it a paper chase because you spend all your time in the library looking up cases and basically chasing papers around. They're not going to have access to a library. It's not going to have access to law books. It's not going to have access to the highly qualified and experienced professors that the regular University of Texas Austin law school has. And more than that is he's not going to have access to the other students. And this is going to be very important because oftentimes in lawyers, they network a lot. You find your new first job by networking with the existing lawyers. Oftentimes when you become a prosecutor or you become a defense, you all know each other because you went to school together or you have school ties. And so there's a lot of almost kind of a good old boys club mentality of law during this time. And so he doesn't have access to those other students. And plus, as you know, part of being a lawyer is you have to learn how to debate. Well, it's very hard to debate with yourself. And in fact, if you're talking to yourself and you're asking questions and answering them and arguing with yourself, people throw you in a nice little padded room. And so you don't want to do that. So the Supreme Court did come in and say, University of Texas, you have no choice. You are in violation of the separate but equal Plessy versus Ferguson. You are in violation of the Equal Protection Clause of the 14th Amendment. Therefore, you must allow Heman Sweatt into your law school. As a result, the University of Texas will, in fact, their law school will, in fact, be desegregated. Shortly after that, their university will be desegregated. And this is going to be a tactic that the NAACP, which helped him with this, is going to use again and again and again to promote desegregation in many other facets of American society. It is important to note that the lead lawyer on this was one Thurgood Marshall. And Thurgood Marshall is going to, in just a few years later, will be the lead lawyer on the Brown v. Board of Education, which, of course, will lead to desegregating of all public schools in the United States. All right. Thurgood Marshall will eventually be the first African American appointed to the United States Supreme Court. Although, in all fairness, by the time he's appointed, he's already spent so much time there arguing cases, he probably should have just been given an office anyway. Thurgood Marshall was the person who came up with the plan of let's use Plessy v. Ferguson, because as you look around, the schools were never, much like the University of Texas, were never really equal. So let's try to push it in that direction and see what we can do. So it actually starts with Paint. Sweatt v. Paint a few years before Brown v. Board of Education, but that's probably one of the first really important civil rights cases that the Supreme Court is going to decide. Also, it is important to note that the Supreme Court decided this case unanimously. In other words, all 9 justices came in and said that this was not this was not a legal situation, therefore it had to be fixed. All right, I'll talk to you later, and stay safe, stay well.